I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are jumping into number 265 on our compilation list. For this compilation, we will be in 3 different courtrooms. Don't forget to like, comment, share, and subscribe. As always, commentary will be added to these proceedings and chapters will be added for your convenience. Now, the first judge's courtroom we will be in, unfortunately, is an unknown judge, but we do know which state it is coming out of, and that is the state of Indiana. Shout out to Sovereign Citizen Chronicles for sharing this proceeding with me, but the young man in this proceeding definitely has his sovereign citizen head on. Second, we will be in the courtroom of Judge Elizabeth McClintok out of the state of Colorado. And last but not least, a YouTube favorite, we will be in the courtroom of Judge Jeffrey Middleton out of the state of Michigan. It's about that time, guys. There's no need to delay. Let's jump into 265.
State versus Ryan Rohrer, 20Z04-2510. DM 2105. Thank you. You didn't sign it, did
No,
you?
I did not.
Did you? Oh, you don't?
No.
Okay. Did you read it?
Yeah.
Do you understand it?
Not all of it. No, I do not.
Do you need me to read all of it to you?
No, some of the things in there don't correspond with what I know of the law. So I just sign it.
Okay. Is there anything in here that you're saying you don't understand?
Yeah.
Okay, then we can talk about that. Can you raise your right hand to be sworn in? Do you swear or affirm any testimony you'll give will be the truth?
Yes, sir.
All right, thank you. You can have a seat. State your name, please.
I wish to not state my name for the record, Your Honor.
Sir, that's not optional. I need you to have a security officer come in here, please. Sir, I don't want this to go sideways. You will tell me who you are. There are certain minimum things that I have to be able to establish. I'm in no way going to do anything that you would believe is violative of your rights, but I can tell you that if you do not identify who you are, I am within my rights to hold you in direct contempt of court, which I do not want to do.
I don't want that to happen either.
And neither do I. And I have had another person in the past do this, and that person was held in contempt.
Most of them are.
Well, I have to be able to know at a minimum who is appearing before me.
Did I say that I'm here on special appearance?
If you want to,
Edward Rohr?
if you want to use, there's certain language that I've heard people use in my career, and by and large, I don't mind it. I mean, whether it's sovereign citizen, whether it's not sovereign citizen, whether it's certain, whether correct or incorrect legal arguments and beliefs, generally speaking, I don't mind it all depends on what you say and how this progresses.
Correct.
If it goes the way I think, it's not the first time I've dealt with this. But I am, how do I say this? I've never had a problem with it. I mean, if people want to use that certain terms, it's usually not a problem as long as I can get the bare minimum information. But if you absolutely refuse to identify yourself, and if it appears that you are the person who, at least on paper, is charged, and I can't establish who you are, I'm going to have to find you in direct contempt. And I do not want to do that.
So I can't go on a special appearance on behalf.
Well, what do you mean by that?
Well, I'm not.
Probably yes, depending on how you phrase it.
I don't know the proper phrasing, sir, but I'm not the corporate fiction
Okay.
is on that piece of paper.
Okay. So do you believe that you are the person who's at least listed in the paperwork? Okay. All right. So the name that you were given when you were born, whether it was given to you without your consent, I don't care. Was it Ryan Rohrer? Okay. And the date of birth, to the best of your knowledge, the date of birth that some individual or on a birth certificate said that you were born, was it June 4th of 1987? I can handle that. You're not saying that you are the wrong person here today on this case. Okay. excuse me, can you get mail? Can you receive something in the mail from the courts at the address that's written on this form?
Yep.
Okay, it's the address we have on file. That's good enough for me. And you've already taken an oath to tell the truth. Okay, did you hear and understand? No, I'm sorry. You said that there are certain things on here that you may not understand. Can you tell me what they are so I can see if I can help you understand?
So one of the, for the attorneys,
I'm sorry, what?
or court-appointed attorneys,
Yeah.
there's not a section on there for representing yourself with co-counsel,
Oh, if you want to represent yourself, that's fine. You have the right to do that.
but do I also get the right with co-counsel
Well,
from the state? Because
co-counsel,
the state is the one pushing the
right,
charges.
co-counsel is not, and again, I know that you said that you might not know all the terms and.
I do not.
Right. And there may be terms that I use that you understand what they are, but you might use a different term. Co-counsel is not I'm not telling you what to say. Co-counsel wouldn't be the appropriate term. At most or at best. Sorry, hold on. I'm losing my voice. Indiana law does not recognize hybrid counsel. You either represent yourself or you don't. However, there is a mechanism that I would not deal with today. This is too soon in the proceedings. There is something called standby counsel that might end up occurring in your case. It's too soon to tell that right now. The court could appoint standby counsel to assist you as needed, but it's not co-counsel. And their duty or their obligation to you is very limited. Regardless of that, you do have the right to represent yourself. I'm not making you hire a lawyer. And by a lawyer, I mean an attorney. Lawyer and attorney are synonyms.
You know, is that part of the bar association?
Right. An attorney, when I say attorney or lawyer, I mean they're interchangeable terms, who has a law degree and is a licensed member of the Indiana bar. I'm not making you hire one of those people. But you do have the right to hire one, and if you can't afford to hire one, I can consider appointing you one if I find you indigent. Your other option, yes, is to represent yourself. You don't have to have a licensed attorney to represent you. So as what you're telling me, that as of right now, you're not planning on hiring a lawyer?
I don't know.
Okay.
I need counsel because I don't know the terminology and all of the laws. So I do need some type of counsel. I don't really want to have a court-appointed attorney because they are part of the bar association and they're working with the state against the individual in the docket.
If you wanted to hire a lawyer, could you afford to hire your own?
I would need some time.
I'll give you time to do that.
Okay.
So then here's what I'm going to do. I'm going to mark down on my order because I only have certain options that I'm giving you time to hire a lawyer. I'm not making you hire one. If you choose not to hire one, that's okay with me. And we'll address if no lawyer is representing you at your next hearing, then we'll talk about that and see what your options are.
Thank you.
Huh?
Thank you.
You're welcome. Were there any other matters in this that you didn't understand?
I'm sure there's several, but
Well, is there any question that you have?
not at the moment.
Well, if you have a question at a later hearing, ask me. I would prefer not to do it today anyway because it's very difficult for me to talk right now. Are you telling me right now you don't have any other questions about the rights in this form? Okay, well, you can ask me at the next hearing if you have any.
Yeah.
So I'm going to give you the future court date, which is an omnibus, further proceedings and status of counsel.
What does that really mean?
Which one?
Ominous?
Omnibus.
Omnibus.
It's treated in the law really as a filing deadline. There are certain limited motions and or defenses that by law have to be filed by the omnibus date. And if they're not filed by the omnibus date, they either will be or may be deemed waived. My job is at least in my opinion, my job is to not change anybody's way of thinking or make them think the way that I do, or necessarily even have to agree with me. But you're telling me that there are certain things you don't understand, and while you have every right to have your own belief system, to a certain extent, of course, if your belief system results in you getting in criminal trouble and it's not a recognized defense, then you're at your own peril. Your own belief system may cause you more harm than good. If your belief system also interferes with the proceedings of the court, there's a lot of case law on the sovereign citizen type of movement, and I'm not saying you're a sovereign citizen. Sometimes having a certain belief system can get you in hot water in court. I've been pretty lucky. I haven't really had to have, that hasn't occurred a lot. I can get along with about anybody. My point is this: if there are things you don't understand, irrespective of whatever understanding or belief system you may have about the criminal justice process, I strongly urge you, and it's my duty to urge you, to hire an attorney to help you understand these things. And because I don't want to get into a situation where you say, well, I refuse to have a lawyer represent me, but I want you to have somebody at my side, which we have to pay for.
Well, the state
Even though
is
you can
putting
hire your own.
charges on me.
I
And didn't
understand
want to
that.
have any contract with the state at
Correct.
all, so.
Correct. And we don't need to get into I may be saying more than I need to at the initial hearing, but my goal is if I say something that perhaps saves time later, why don't I do it now if it saves me an hour later? There is no requirement under the law. I've dealt with this dozens of times with individuals in court. I'm not here to have a debate with you, and I can tell you're not trying to have a debate. You do not have to enter into any sort of contract. The law is crystal clear. If you enter the borders of our state, you are subject to our laws. Maybe there's some exceptions to that. I don't know if they apply to you. We'll figure that out later. Anyway, I got to get back on track. Are you aware that you, or whatever term you want to call yourself, has a hearing, it appears, on August 24th at 10 a.m. in LaGrange County?
Yes, sir.
Okay, because I don't want you to have a warrant. Huh? I haven't even gotten there yet. I got sidetracked. Thank you for the reminder. I would have forgotten. Other than what we've discussed and what you've read in this, do you and everything so far stated in the possibilities? Okay, then I need to the charge. On October 23rd, 2025, the state of Indiana charged you there with one count of Class B misdemeanor violation of in-state registration requirement, omitting formal part of Indiana, but that was required to be registered in Indiana. I'll say this is a charge I very rarely see.
Yeah.
And I wouldn't be surprised if this could get worked out, at a later date. Okay, so I'm required to enter a preliminary plea of not guilty. It becomes a formal plea of not guilty in 10 days. I do that for everybody today. I'm going to set your next hearing for a combined omnibus further proceedings and status of counsel hearing on Monday, September 21st, 2026 at 8:30 a.m. If you've not hired a lawyer like we talked about, who's a registered member of the bar, who's entered, and if you haven't hired one, who's entered a written appearance, then you do need to be here September 21st at 8:30. It is also possible that you might be able to resolve this case directly with the state on that Monday, but if not, that's okay too. I've got your court date highlighted. Do you have any questions?
No.
Okay, I'll see you September 21st. If you don't have a lawyer here, have a good day. I'm going to put on here, court notes, defendant did not sign advisement of rights form, which is fine. You didn't have to sign it, but so deal with that as needed.
Well, we've come to the end of this first proceeding with Mr. Ryan Rohr. And shout out to the judge, man. This judge, I really like the style that he held this proceeding with. He wasn't really bothered by the sovereign citizen stuff. He said, man, listen, you can call yourself whatever you want to call yourself, whatever terms you want to use. I'm not too bothered by that as long as it's not interrupting the process. It seems like the judge was sitting in a chair made of pollen because he could not stop sneezing and coughing and so on and so forth. But I love the way he handled the situation. And shout out to Mr. Rohr. He understands that he needs some type of standby counsel if he's going to have any type of effective defense. So now let's get ready to jump into Judge Elizabeth McClintok's courtroom.
Up. We have several cases. Come on up, sir. All right, these are cases 25T448, 25M318, 25M352, 25M375, and 25M395. Mr. Shadowins, let's see, you appear on bond today. We had a failure to appear, I believe, on May 4th. I'd issued warrants for your arrest on that date for failure to appear. I've been in contact. The doctor from Colorado Hospital, you were supposed to have an appointment on May 8th to do the competency evaluation on these cases that had been ordered by Judge Kilgore. My understanding is you did not have that appointment.
That would be correct, due to a change of address to the likes of which I am in possession of prima facie evidence I have not had the opportunity to file into the record. So my apologies to the court for the failure to appear. I was in between addresses.
Okay. But
I
what
did
about
complete court requirements of Judge Kilgore and report to mental health. I was under the impression there were no active cases or pending hearings, according to the DA's office and mental health. I was told
no?
by email. I have the emails, ma'am. I was told.
Okay,
by them.
show me the emails then. Because I spoke with or emailed with the doctor this morning to confirm that you did not follow up on those appointments. And she had said that, no, you did not follow up on those appointments. And we need to get these back on track because these cases are pending. And I need this competency evaluation to get done so we can get these cases moving.
Ma'am, I was under the impression, for the record, that mental health was to report back to me, end quote. She said she was going to talk to you. The statuses of these cases has been a matter of question.
No,
I was told
these cases are still pending. These cases need to be moving. The only thing that's holding them up is a determination about your competency.
Ma'am, I demanded these matters be settled by right of equitable subrogation.
No, sir.
Judge Kilgore admitted on record it's a, quote, failed prosecution.
No, sir. I've listened to all of the records in these matters. The last time you were in court, what was ordered is you were supposed to go through these competency evaluations. You were supposed to get those done. And if you did not get them done, you were going to be sent back into custody to have them done while you were in custody. That was the last thing that was ordered in these matters.
I have the emails and
Sir, I have the records of when you were in court.
I have not
And I've
presented
listened to them.
evidence, ma'am.
Sir?
How would you like me to enter the evidence you asked for into the record, ma'am? The clerk was unable to process it this morning.
So
I have
what are
prima
these
facie.
emails? What are these emails?
This is mental health as well as postal receipts for the change of address. My mail was on hold.
What?
So
You have
apologize.
emails or letters? Which are they?
Ma'am, may I speak to answer?
Emails or letters, sir?
All of the above, as well as postal receipts. My mail was on hold. I apologize to the court for my failure to appear. I was not served. I was told by the...
What? Served with what?
Ma'am, if I may speak and
Served with
interrupt it,
what,
please.
sir? Served with what?
As we can see, Judge McClintok is fed up with Mr. Shadowing's shenanigans. She's already had to tell him a couple times to stop talking over her. He brings up prima facie, which basically is him saying that he has some type of proof, right? That at first glance, it is going to seem to be true or look to be true. And it is enough to win a claim. If the opposing party does not disprove it, it can actually win him a claim. So that's what he keeps talking about, prima facie. He keeps holding up the paperwork. But this thing isn't going too well, and it doesn't seem like it's going to end well. But who knows? Let's see.
any hearings. I was told.
You were in court
Ma'am.
the day that you were supposed to be here. You were told your next court date.
I'd like to be heard on a
Sir.
record on the matter to answer your questions. How would you, first and foremost, how would you like me to present this evidence into the record?
Give it to my clerk.
Thank you. I was not noticed of any hearings. I was told by 2 senior investigators at the DA's office, I quote, did not have any pending cases or hearings. I have a video that went viral on the internet of the DA's office obstructing justice. I was unable to file discovery into the matter, Your
Sir,
Honor.
The
It's on
DA's
the-
office does not give notice of court hearings.
I was
You
ejected
here-
from the building.
No, sir.
I signed up with the
Sir.
sheriff. I signed up with the sheriff's office to be noticed from the court. They could not do that, ma'am, because I was in limbo with my address. All my mail is on hold. You have the postal receipts, prima facie.
Sir, we do not provide you notice of court dates by mail.
I signed up for a contract with the sheriff's office to be noticed of hearings. No such notices came through. My mail was on hold with the post office. My apologies to the court for the failure to appear. I was under the impression there were no pending cases. There were no pending hearings. Mental health told me they would report back to me after petitioning the court for clarity of the status of the cases. No such notice was given nor service from the courts at all, Your Honor.
No, Mr. Shadowins, that is incorrect, and you know that is incorrect.
You're in possession of
No,
prima
Mr.
facie
Shadowins.
evidence.
No, Mr. Shadowins, I'm not in notice of anything.
I said possession.
No,
Point of
sir.
clarity. You have physical
No,
possession
sir.
of prima facie evidence to show just cause.
No,
Am I
sir.
entitled to understand the nature and cause of the proceeding today, Your Honor?
Yes, sir, you are, and you have
Thank
notice
you.
of
I was under the
proceeding.
impression,
Stop talking over me, sir, now.
I don't understand the nature.
Stop talking over me. I am trying to explain it to you.
Yes, ma'am.
You have notice of the proceedings. You have been served a summons and complaint in each of the proceedings. That has been explained to you. You stop. Take the gum out of your mouth and spit it in that garbage can right now. Right now, sir. You have been served a summons and complaint. The documents you have showed here are just e-filing documents that are well from December of 2025.
Negative.
That has nothing to do with what we are doing
Your
here.
Honor, with respect.
Stop talking.
With
over-
respect to the nature and
No,
cause of
sir.
the, I
Well,
cannot proceed.
Stop talking over me, sir.
I wish to enter a plea into the record, not
Okay.
guilty, all charges. A jury
can
trial is
enter-
demanded, civilian due process of law is demanded. My question to the court on the nature and cause, I was under the impression I am here by special appearance to show just cause for a failure to appear. I have no other issues in front of me this morning, Your Honor.
No.
I was,
And you're going to be taken into custody today, sir, so that we can complete your competency evaluation that you have refused to
Ma'am,
appear
these-
for.
it's right
on
here, prima
every-
facie, Your Honor. I was told by mental health they would report back to me. No such
sir.
notice was given. I couldn't
Notice
receive
was
notice
given.
from the courts due to a change of address. I'd like to read the evidence into the record, please.
No, sir, you will not. You
Let the
failed
record
to
show
appear.
that I have been denied a defense. A trial by jury has been demanded. I have already sent all of this to the State Attorney General Phil Wise, who has obstructed justice and refused to respond in these matters. My right to equitable subrogation before Judge Kilgore was demanded thrice. I also challenged the jurisdiction of the court. Judge Kilgore admitted on record in front of Teller County Sheriff's deputies, Your Honor, quote, "It's a failed prosecution," end quote. I have since been retaliated against. Now, I have teamed up with attorneys, including the Disabled American Veterans. I'm moving this to federal jurisdiction.
Thank you, sir.
There's no victim
You're
in this
done
case, Your Honor.
Your bond is being revoked so that you may go
Who is
into
the victim?
custody and you may have your competency evaluation completed because your failure to cooperate out of custody in this matter. We will have the competency evaluation completed in a forthwith manner according to statute.
Okay.
I have been denied a defense. I was denied the right to read evidence into the record. And I was never given discovery. I could not plea without evidence, Your Honor. That's all a matter of record. There is no
Also be
victim.
appointed
Who is-
the office
What is
of
the
the
Sixth
public
Amendment?
defender in order to represent yourself represent you.
What
because
is the nature of a crime having
in
been
this
committed?
matter. In all of your cases, you have been provided notice in regards to the summons and complaint and all of the discovery in this matter.
Which I have abated via affidavits the prosecution has not responded to. My facts remain concrete evidence. There has been no response from prosecution. I don't even have evidence and discovery.
Thank
The
you.
accounting has been demanded for settlement. This is unconstitutional, Your Honor.
Thank you.
I cannot stand for this.
John, what's going down?
Let the record show I have been denied due process of law, civilian due process of law, a trial by jury. I'm still speaking, Mr. Sandlin. I must remain harmless. I am not done addressing this court, which is my First Amendment right.
Thank you, sir. Appreciate it. Yeah, so the public defender will be appointed for Mr. Shadowins on all of his cases at this time. In regards to his competency evaluation, that will be ordered forthwith in custody.
Understood.
So, and I would request that the public defender obtain discovery in all matters and provide copies to him. So there's no question that he has that information. So,
Understood, Judge.
all right.
I apologize, but would you mind reading those case numbers just so I can get
Yes,
all of them open to us, please?
yes. They are cases 25T 448, 25M 318, 25M 352, 25M 375, and 25M 395. I've notified the Colorado State Hospital and Dr. Elizabeth Fuller that Mr. Shadowins would be taken into custody today, and then I expected them to complete his competency evaluation immediately.
Understood.
This can't be delayed any longer. All right. In regards to, do we happen to have the Teller County Jail online yet? No, not yet. All right.
Well, I figured that it wasn't going to end up too good for Mr. Shadowings. We see that he was taken into custody. He has not done his competency hearing. He came up with all types of reasons why he had not. You know, he didn't receive the mail. He signed up with the sheriff's office to receive, notification that the proceedings were happening. And the judge is like, we don't even do stuff like that here. He brings up, where's the victim, jurisdiction, all of the things that we've heard in the past. But I saw from the beginning that this wasn't going to go too well for Mr. Shadowings. And, hopefully we'll be able to follow up on this and see how this all plays out. But if he keeps up this type of behavior, it's going to be a problem for him. Do you guys feel that he needs a competency evaluation? And if you were the one giving him the evaluation, what would your evaluation be? Now let's go ahead and jump into Judge Middleton's courtroom.
Mr. Hicks, why don't you come on up and talk to you, or Mr. Aiken? That wasn't his.
You're on special appearance and fine.
All right, well, we'll talk about that here. This is file number, what's that?
You're on special appearance in the divine and living.
Okay, could you hand that to me? Well, first let me call the case. This is file number 222036SM. Give this back to you. You don't want to lose this. This is a birth certificate for Justin Michael Aiken. And he happens to be the person that got this citation, Justin Michael Aiken. I don't want to keep that. I don't want you to lose it. You need it. Anyway, that's you. Mr. Aiken, you're here under one appearance or another. You got a citation charging with having no insurance. The last lady had the same charge. That's a misdemeanor. It's punishable by up to a year in jail, a fine of up to $500 and not less than $200. The second count is the one that carries a driving suspension. That's called driving suspended. That's a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. That carries 2 points and it requires that your license be suspended. So that could affect your ability to drive a car. And then the third count is a registration plate violation, which is a civil infraction. I don't know if there's any sort of plea offer. At this point, there probably isn't. What was your advice, Ms. Jackson?
I advised him that he should plead not guilty, ask for a pretrial, and pay off what is suspending him, which is basically a couple of tickets, I believe, out of Greenwich County. See if he can't get some reduction on that charge.
That's not bad advice. Mr. Aiken, she's recommending at this point that you plead not guilty, and I don't have a problem with that. Your driving record shows that you had some previous insurance tickets that you didn't pay. And then she indicates you may also have some things from Indiana, LaGrange County.
Branch me,
What's that?
Branch County.
Branch County? Okay, let me look at this, because I did look at this yesterday. The staff has been talking with you. They say you're very polite and respectful, but may not completely understand everything. Your driving record shows that you are currently suspended. You do have an ID. You have Coldwater, March of 22, failed to comply with judgment. That means you didn't pay the ticket. And so her advice is probably pretty good. What would you like to do, sir?
Well, there's case laws here that states that the use of an automobile as necessary to the earnings of a livelihood as modern life requires use in the interest of realism to conclude the right to use as an automobile on the public highways partakes of nature of a liberty within the meaning of the constitutional guarantees. Barbarian versus Luzier, 1958, 139, 82D, 869, and then the right to operate a automobile upon the public streets and highways is not a mere privilege. It is a right of a liberty, the enjoyment of which is protected by the guarantees of the federal and state constitutions. Adam versus City of the Pocatello, 416 P.2D, 46, 4891, Idaho, 99, 1966, and a travel right to employ an automobile as a means of transportation and to occupy the public's highways with other vehicles in common use. Campbell versus Walker, 78, Atlanta, 601, 603, 2, Boyce, Dell, 41. Also, the word automobile connotes a pleasure vehicle designed for the transportation of persons on highways. American Mutual Liability Insurance Co. versus Chaput 60, A.2 D2, 118. Motor vehicle, the term motor vehicle means every description of the carriage or otherwise convenience propelled or drawn by mechanical power and used for commercial purposes on the highways. The term used for commercial purposes means the carriage or a person or property for any fare, fee, rate, charge, or other considerations or directly or indirectly in connection with any business or other undertakings intended for profit. A motor vehicle or automobile for hire is a motor vehicle other than an automobile stage used for the transportation of persons for which remuneration is received. International Motor Transit Co. versus Seattle 251 P120.
So does that mean you want to plead not guilty to this stuff?
Yes.
All right.
Because
I don't know if there's a club, you pay dues. As I said, the staff said you've been very polite and respectful, but you are woefully misinformed. People keep coming up with these.
I have one more thing.
Well, anyway, everything you just said has no meaning to whether or not you need a valid driver's license or insurance in the state of Michigan.
Well, we see this young man here in Judge Middleton's courtroom. He comes right in. He says, listen, I'm here on special appearance in the divine and living, whatever that means. But this is why I love Judge Middleton, because he knows how to handle sovereign citizens, whether I've seen him get aggressive in the past or the way he's handling this young man right here. Because the young man is respectful, it sounds like everybody likes him in the courthouse, you know, wherever he may have to deal with this case at. It sounds like everybody has good things to say about him. And Judge Middleton acknowledges that, and he's letting them know, like, listen, I feel bad for you that you're going down this road, that you've gotten hold of this poisonous information, because, you know, you're a good young man. You seem to be pleasant, nice, polite. I don't want to really see you go down this road and mess yourself up, but let's see how the rest of it plays out.
And the problem is, Mr. Aiken, you could take all this misinformation and really get yourself in a difficult circumstance. I don't know who's teaching you this, whether you learned it yourself off the internet or you've got a mentor that is taking you down this rabbit hole. But I don't want you to get yourself in a situation where you're going to have to live to be 99 years old to get your driver's license back. So first of all, Mr. Jackson's advice that you pay the ticket in Branch County would be helpful. Everything you just said has a thimbles full, an empty thimbles full worth of effect on anything. Your driver's license is suspended by the state of Michigan. You can travel all you want, but you can't drive a car until you get that cleared up. Secondly, you're not an independent nation unto yourself. You need insurance. I don't want you to get all sideways where you can't get your license back from following this irrelevant, meaningless information that you've been provided with. You seem like a nice young man. So I'm going to show you a plea not guilty. Would you give Mr. Aiken his birth certificate back? I don't want him to lose that. Now, you said there was something else you wanted to tell me?
Yes, if that's okay, Your Honor.
Yeah.
Okay, it states right here, under U.S. Supreme Court decision, that common law is the real law, the supreme law of the land, that codes, rules, regulations, policy, and statutes are not the law. So therefore, as in insurance, regulations, title, tags are not law. That's as it's stated here, Rodriguez versus Ray Donovan, U.S. Department of Labor, 1769, or 769 F 2D 1344, 1348, 1985. And then U.S. Supreme Court decision 1796, there every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent, Cruden versus Neal. And then this decision has never been overturned.
Okay. I'm not sure where you get this stuff. If that were true, you wouldn't need me. You wouldn't need police. You'd have anarchy and people rioting in the streets and doing, we're about there now. Feel like that somebody says something they don't like, they shoot them. Somebody says something they don't like, they punch them in the nose. They feel like everybody else's property is their property. There's something here in the United States, here in Michigan and here in St. Joe County called the rule of law. And the judges don't make the laws, the legislature does. The judges are sworn to enforce them. So at this point, somebody gave you all this information, which doesn't really affect anything, and it isn't a legitimate defense. You're entitled to have it. You're entitled to be misinformed. I can't, and you're entitled to believe what you want. You're entitled to have a trial in front of 6 jurors.
Yeah, we can do that.
This isn't even, that stuff won't even get to a jury. The only question would be, did you have insurance and were you driving? Anyway, as I said, I don't want you to get on the driving suspended merry-go-round and you'd be unable to get off of it. Whoever is giving you this information is doing you a terrible disservice. You got these tickets in other jurisdictions that you didn't pay. Now you're suspended. How'd you get here today?
I got a ride. Somebody gave me a ride.
All right. Well, don't drive anymore until we sort this out. Stop driving. I would like to see you get back on the right side of having a driver's license. This stuff is not helpful. It doesn't aid your cause. It has little meaning. And the bottom line is you need to have a valid driver's license. You need to have insurance. This stuff doesn't carry any lawful weight in any court in the state of Michigan. So I'm going to show your pleading not guilty. We'll send you out to the court office. We'll have a pretrial. You can share your thoughts and beliefs with the prosecutor. They'll probably just make them mad. But Ms. Jackson's advice is a good one. If you can go get the tickets paid off, get your license available to get it, they may give you some consideration. But you live in Constantine, which is a little place.
Right.
Every time you drive, they're going to pull you over again.
Yeah, it's
We're going to
different.
be on the merry-go-round and we won't be able to get off of it. So, like I said, you've always been polite and respectful, and you're entitled to believe what you want. But this isn't helpful to your cause. So we'll get a pretrial, let you share that information with the prosecutor, see what they want to do. But Ms. Jackson's advice, I think, is good advice.
Okay.
All right, Mr. Aiken, why don't you take him out to the counter? Now, what's going to happen next, and I apologize, once upon a time, we used to do the pretrial right here at the time of the arraignment. But with county cases, we're not able to do that presently. Are you missing work right now?
No, not right now.
Okay, good. I don't want you to have to take time off from work to come back here, but we'll talk further about this. And if you want a trial, you're ultimately entitled to have one. My hope is you could get some of this stuff squared away and the prosecutor will give you some consideration to help you get your valid license back. But when you were young, you took driver's ed, you did all the steps you needed to do to get a valid license?
Correct. I did then. That was before I actually started researching into law, actual common law of the United States of America, which is common law, God's law. Legal is undoing of God's law, illegally. That's what it comes down to. I mean, I know you don't know it. It's just there's a whole bunch of fraud.
Well, I didn't just fall off the turnip truck. I've been here for 42 years, and people have been making these harebrained arguments for years, and they don't carry any weight. And I'm sorry that you have gone down this path, but it isn't going to be beneficial. And the better, and you went to all the effort to get a driver's license. Don't throw it away because of some mistaken beliefs about something that was rendered in 1796. So anyway, we'll send you out for a pretrial and we'll see where this goes. But I appreciate the fact that you are polite, respectful, and you have a right to believe misinformation if you want to, but it isn't in your best interest. All right, good luck, sir. We'll probably talk further.
Well, Judge Middleton kept on trying to help this young man, kept on trying to tell him, like, listen, this information that you have gotten a hold of is come from a poisonous tree. It's come from a tree that have sabotaged many people's lives here in the courtroom. And with everything that Judge Middleton said, that I believe from a sincere heart, this young man did not listen to any of it. So, I meant, hopefully someone can get a hold of him. Hopefully he goes home and listens to the proceeding over, or just listen to the words that Judge Middleton was saying to him, let it run through his head and make the right decision and just get his license back and do what he has to do instead of going down this rabbit hole and, like Judge Middleton said, getting your license at 99. But hey, this is number 265. I sat in through the whole thing. I know you guys aren't used to that, but as always, thank you for joining me here at Sovereign Citizens Hall of Fame. And until the next compilation, guys, I'll see you then. God bless.
I'm not threatening you. Say one more word and that's 30 days. 30 days.